They're so used to doing what they're doing. That's the problem. That's where we're at now. It's been things have been happening for so long. I feel honestly like they think it's normal.
Meeny, miny, moe, grab a tyrant by the toe.
Today, Adrienne is here to tell her story that has made it all the way to the West Virginia Supreme Court of Appeals. The case will be heard by students, the public, and the media on April 1st at the WVU Law Clinic. Now West Virginia is under fire for their mishandling of CPS cases and the detriment that it causes to families throughout the state. Adrienne's case is so important because it demonstrates just how far the system will comfortably go to achieve their goal. What we have all become fed up with is the Berkeley County judicial system's blatant corruption done out loud and with total indifference to violating rights, bypassing procedure, and forcing the community to be okay with the result. Adrienne, you have an incredible story. So tell me a little bit about what is going on in your world right now.
Well, this has been a long 4 years. This all started, I was going through a divorce proceeding from February 2022 through August 2022. It was finalized in August. I was married 17 years.
Okay.
I was a full-time stay-at-home mother for 15 years. I've never been arrested. I've never had any CPS involvement, no type of a criminal history, nothing. By January 2023, all of a sudden, after getting divorced, all of a sudden I'm no longer fit to be in my children's lives.
How long was it after your divorce that happened?
4 months. So my divorce was finalized and I had 50-50 custody per the state's presumption of a fit parent having 50-50 custody. And my children had spoken to the judge and said that they wanted 50-50 custody. And less than 4 months later, reports started coming in. The first was made, I wasn't find this out until later, the first was made by a woman that's dating my ex-husband. They were completely fabricated, saying that I had chased my daughter down with a spiked bat in front of Spring Mills Elementary School. You would have think that would have made the front page of the news, right?
Yeah, were there witnesses to this?
There was no witnesses. There were no witnesses. The only witnesses were my ex-husband and his girlfriend, who were not there.
So while you were married, there was no issues, no reports, nothing like that. And then 4 months after your divorce, all of a sudden, all of these accusations come in.
Believe it or not, there were reports made against my ex-husband.
Oh.
So my ex-husband does have a criminal history, and he does have CPS history. He, none of which at the time were substantiated. Throughout the course of the divorce, he was being investigated for dragging my son up the stairs by the hair, ripping his shirt, and beating him until he was bloody. Well, fast forward, in January, all of a sudden these reports come in, 2 reports, saying that my daughter was chased with a spiked bat in front of the school, that they all climb through the window every day, they don't have keys to the house, that they're not being fed, there's no food, clothing, shelter, medical care.
These were coming directly from the adults in the situation, not the children?
These are coming directly from the adults. The CPS workers had interviewed my children at the school without my knowledge.
That's a big deal. You're saying that the workers came without your permission and interviewed your children. Can you tell me about that?
So apparently, I guess my ex-husband gave them permission and pushed them to go to the school and speak to my children. After they spoke to my children, they came over to my home, and according to the video camera, because I was not aware that they were coming, they went to my neighbor's home, staked out my home, and waited for my children to get off the bus. Then they watched my children come into the home, and they essentially trailed in behind my children into the home. I had no knowledge that they were there. There was no warrant.
Was there another adult there?
There were only 2 caseworkers, me. I was upstairs cooking dinner and cleaning, and the children.
They were downstairs while you were upstairs?
Yes. And so then all of a sudden the children said, oh, you can come upstairs, because they felt comfortable because they had just seen them at the school. The caseworker that came to my home, she was so young. She had on Doc Martens. She looked like she was about my daughter's age, 13, 14. Apparently, she had just graduated from Fairmount University, had no children of her own, was 21 years old, and had only been trained for 3 months before taking on the role of removing children from their homes.
Wow.
I looked on LinkedIn so I could find out who this woman is and what her expertise is. And her name was Abigail Nestor. I currently have a federal lawsuit against her. She was a resident assistant for the school dorm at Fairmount University and a hall monitor. That was the expertise that she had before being trained for 3 months.
Zero qualifications.
Zero qualifications.
To ruin someone's life.
No psychology classes. She took classes in terrorism.
That is not a prerequisite.
Exactly. So either way, they came into my home. They coerced me into a 7-day in-home safety plan where they said that I needed to get someone to come and supervise for 24 hours a day for the next 7 days, and that they would check in, and if all was well, that I'd be cleared and everything would be fine.
Was there anything that kind of led them to that? Just the reports?
Only the reports. And ironically, in the petition, my ex-husband, when he was interviewed, the first thing he said was, "I'm already represented by counsel."
So he was prepared.
So that stuck out to me because if you're worried about our child cutting herself, why didn't you get her medical attention? Oh, but you hired a lawyer. First thing. It wasn't until years later that I realized that his attorney, who also works as a Bureau of Child Support Enforcement attorney and is an appointed guardian ad litem for the court. It wasn't until later that I realized that she was the composer of the symphony of events that led to the taking of mine and my children's fundamental liberty interests.
You also, there's another important factor here that you've told me about, which is your husband's significant other.
Yes.
Who happens to also be a part of the same system.
Yes, she is. She is a behavioral analyst who subcontracts with CPS. She was a caseworker at Washington High School. And ironically, that seems to be the same exact high school that Taylor Staubs, Steve Redding's stepdaughter, works at.
We know that name.
So Taylor Staubs was the interviewer of my children along with her best friend, Jenn Hyde. They both made the recommendation that my children be placed with the abuser. They withheld the inculpatory evidence that was incriminating of my ex-husband as the abuser, and also withheld the exculpatory evidence against me that I was innocent of any wrongdoing. They made the referral that my children be placed in the sole care, custody, and control of my ex-husband, and all of this was done under the table, ex parte, with my husband's attorney, my ex-husband's attorney, Debbie Flowers Payne.
So, seeming like, did you feel like it sounds like you feel like you had they weren't hearing you at all.
I was completely ambushed. There were no neutral arms of the court. The CAC interviewers were in the pockets of the judges, the guardian ad litems, and my ex-husband's attorney, who also is a Bureau of Child Support Enforcement attorney and a registered guardian ad litem herself. And so so it's like there was this cabal, and my case was already predetermined before any evidentiary matters were heard.
It seems like that's literally what we're seeing and making videos and talking about every single day is this Berkeley County Judicial connected system where there's family members, husbands, wives, all related. And how did that impact your situation?
Well, it completely impacted my situation because there was absolutely no due process. We had the 7-day in-home safety plan, and ironically, during the course of that safety plan, my ex-husband goes into the office, speaks directly with Abigail Nestor, and says, "I'm still concerned. My daughter is there with this abusive woman, and she wants to cut herself." And by the 8th day, they had not reached out to the safety resource that had been staying with us. They removed my children on the 8th day. But they had not filed the petition until 16 days later.
So they backtracked.
They removed my children outside of the 7-day safety plan. They did not extend the safety plan. They filed the petition over 2 weeks later, and so they essentially bypassed judicial safeguards. I go 8 months, no contact with my children after they were removed because the department failed to make a referral for visitation. When asked by the court why they did that, they said, we just didn't do it because it slipped our mind. Our caseloads are so full, we're busy. We don't have time that we take.
Rules, procedures, they don't
Who
apply to
needs
everyone.
rules? We took the kids. She's got to figure it out on her own. Okay, well, I'm going to figure it out on my own. Then I'm punished for figuring it out on my own. So even though they had testimony from my children during the CAC interviews, which were headed up by Taylor Staubs and her best friend Jenn Hyde White, it was like, even though they had my children's words saying that they were beat by their father and not by their mother, they completely turned it and shifted it and said, okay, well, they weren't beat by their mother, but their mother's prejudiced and racist against black people.
Can I ask you one thing? If you would have had your ex-husband's attorney for your representation, do you think the case would have been, you would have had a different outcome?
I feel like that woman could be bought. That woman, well, first of all, she advertises herself for father's rights. It seems to me that she has been circumventing judicial processes, utilizing her position for a very long time. And so I don't know if I would have gotten that same representation.
But for us, I guess maybe I'm saying because of her connection to this judicial interwoven system.
I feel like this woman could have drafted documents on behalf of the GAL, which she did, and she could have drafted documents on behalf of the prosecutor, which she did, and then she can draft her own documents and come in and have this one cohesive, ironically cohesive story. Meanwhile, the prosecutor didn't do his own investigation, the GAL didn't do her own investigation, and the department didn't do their own investigation. They all relied on Debbie Flowers Payne to come up with the storyline. And she certainly did. And apparently, I watch a lot of oral arguments. Now, Debbie Flowers Payne and my attorney have been before the Supreme Court. And the Supreme Court explicitly asked Debbie Flowers Payne, were you acting as a dual representative in this case? This was a whole separate case. Because she had brought about an appeal because the lower court had denied it. And she said, no, the children were abused. So the fact of the matter is, the Supreme Court justices asked Debbie Flowers Payne if she had been acting in a dual representative capacity on the website, online, and in front of everyone, and she said, oh no, they were just backlogged, so I was just helping them out. Well, I guess this is just another one of those many, many cases where she's just helping out all neutral entities. She's helping out Taylor Staubs with figuring out what the placement is going to be. She's helping out the department because Casey Putney and Jared Smallwood both had no idea of what was going on in my case. They had their heads up. They relied on Debbie Flowers Payne to give them all the debriefing before each one of our cases. I mean, the thing about it is like I said, I grew up in the days of Perry Mason, Murder, She Wrote, mysteries I love. You want to give me a mystery? I'm going to solve that. Don't get mad at me when I call you out on it too, because they have been threatening my incarceration for talking about my case.
Yeah, retaliation. Talk to me about what's going on with retaliation.
So they were trying to terminate me from the brink. They were not trying to give me an improvement period whatsoever. When I did get an improvement period, and it was hell to try to get that.
How long before you got that?
So let's see. Initially in the petition, it was stated that I was on drugs. I tested negative for all substances. So then the department and my ex-husband's attorney, Debbie Flowers Payne, alleged that I must have psychological problems. Therefore, they're not going to pay for me to get tested. Okay, well, I'll pay the $2,000-3,000 and get myself tested, no problem. Ooh. So I got the referral. I got myself tested. I admitted it to the court, the report.
I did it myself.
And guess what? What Mcglaughlin said?
They weren't going to take it?
oh, we're not going to accept this because you didn't go to our people. Okay, well, you said you're not going to provide me with services to be able to go to your people. So tell me why. Eventually, they do give me an improvement period after I make a big fuss. They do have me go to their people, Eastern Panhandle Psychology. I go there and my report is even more favorable than the one I got. So well, guess what they did at the disposition? They threw out the report from their people and tried to hold my report that they threw out against me. So it's like this whole circle where they're trying to
circumvent every single thing.
They're trying to have a person so confused that you start questioning your own mentality, your own psychology. The supervisor, so after 4 visits, my visits were terminated again. I had waited 8 months for communication with my children. Finally, after the wait list, I had 4 visits. They were suspended. Why were they suspended? Because I was reading Bible scripture. At my adjudication, they allowed Taylor Staubs and Caitlin Cook, the supervisor of the home base visits, to testify. They were not listed witnesses. We objected to them testifying because they were not listed witnesses. Mm-hmm. The judge allowed these unlisted witnesses to testify. Meanwhile, my therapist and my witnesses who were listed were not allowed to testify. Okay, we go back, so fast forward. I'm found guilty of misuse of religion and reading Bible scripture that made the children feel at fault.
Never heard that before in my life.
I mean, show me the statute where Bible scripture is abuse. Nevertheless, it's not abuse. However, the guardian ad litem, Emily Maury, was the judge's former law clerk. So that the judge's employee is a neutral arm of the court representing my children. So they go into the chambers and they draft an order that is completely different and embellished from the record. The record stated I had engaged in misuse of religion. Okay, fine. But the written order said that I had engaged in excessive corporal punishment, physical abuse patterns, failure to provide
What is
food.
a physical abuse pattern?
That, like I had been beaten there.
They're
years.
witnessing injuries, harm, anything? No.
There was no injuries, there was no harm, there was no cuts, scratches, or bruises, and there was no testimony from my children outside of what Taylor Staubs.
Talk to me about Taylor Staubs.
Taylor Staubs, where do I start? It's almost as though they attempted to keep her involvement in my case somewhat repressed.
And what was her role in this?
She was the supervisor for Victoria's house. She conducted the CAC interviews of my youngest daughter, but then had Jenn Hyde White complete the CAC interviews of my 2 older children. But Taylor Staubs was the one that made the recommendation that my children be placed with their abuser and that all contact be cut off with me. Now, the transcripts, of course, only show that she said, oh, I have no involvement. The youngest child didn't say anything. That was her testimony. But she allowed Jenn Hyde White to say, oh, yeah, we have all this information regarding the father, not so much regarding the mother. So who made the referral for my children to be placed with the father? Taylor Staubs. She had a lot more power than what she allowed herself allowed it to be known. Initially, my case was supposed to be taken by Steve Redding. Steve Redding was supposed to be, he was put on, it was initially off the brink. He was put onto the case. They were doing some restructuring within the 23rd Judicial District. So he did not end up taking the case. Judge Cohey took the case. Later, Judge Cohey would move to Jefferson County and Debra Mcglaughlin would take on my case. It was like my case was a big case of hot potato. They were playing hot potato. Here, you take it.
All the way to the Supreme Court.
All the way to the Supreme Court. So the problem is that Taylor Staubs made the referral to place my children with their abuser. She withheld inculpatory evidence that would have incriminated my ex-husband of abuse. and held exculpatory evidence that would have exonerated me of abuse. So she and my ex-husband's attorney collaborated with Marla McGlaughlin, the supervisor of DHS, to figure out how they were going to proceed. Tried to get me to accept a plea saying it's called a stipulation that if you agree to not feeding the kids, we'll take away all these charges of a spiked bat and all these other charges.
Oh, they wanted you to admit to one portion of abuse to drop all the other portions of abuse.
Right, so this is how they scam parents. They have medical care, they have food, clothing, shelter, everything they need, and then some. So I'm not gonna admit to not feeding them because they are fed. And they've never been beaten by me, they've actually been beaten by their father. So I'm not going to admit to that. Well, ultimately, they would terminate my rights because I didn't admit.
For not complying.
I didn't admit.
Right, you didn't admit.
They wanted admissions of something that we were in a contested adjudication. We were in a contested disposition, and yet they were still terminating my rights because I didn't admit to the contested allegations that were never substantiated.
That's how they back you into a corner. And where we're at now is we are at the Supreme Court of Appeals.
So now we're at the Supreme Court of Appeals. So fast forward. The department, my ex-husband, his attorney, the prosecutors, they were all moving to terminate me prior to even being adjudicated. They refused to give me an improvement period, but then they saw that I was not going to back down, and that I was not going to sign anything. So eventually they gave me an improvement period. This was after I was found guilty of reading Bible scripture to my children.
Right. I'm curious to see what they're going to say about that at your hearing. It's a hearing.
It is. So the Supreme Court is having an oral argument with regard to my case. Abuse and neglect cases for oral argument make up less than 4% of cases that are heard for oral argument. Normally, they are with regard to due process, procedural irregularities, and things of that nature. My attorney specifically asked Judge Debra Mcglaughlin, look, you came onto this case after the adjudication. Can you please make yourself abreast of the evidentiary matters so we can know how to proceed? Paid the $1,500, got the transcripts. We asked the judge again, hey, can you read the transcripts and make yourself abreast of the evidentiary matters?
Wait. Are you saying that you purchased the transcripts so the judge would read them?
Yes. So we had, it was Judge Catie, and she transferred the case to Judge Debra Mcglaughlin.
If only their computer system was as interwoven as all the officials and employees of the court.
Exactly. So apparently Judge Mcglaughlin had no idea of the evidentiary matters of my case, yet she took it over directly after the adjudication. We asked her, hey, Judge Catie never looked into our objections. Can you look into our objections? She set up all these, wasn't there, so I need the transcript, and I need you to fill out a whole new memorandum, and we need all this stuff if you want me to consider them.
Obstacle.
So we did it. We did every obstacle. Okay, we did a new memorandum. Okay, fine. We got that. So then when we asked her to review it, I'll never forget it. Do you know what the judge said to us, Judge Debra Mcglaughlin? We said, can you please review the transcript before proceeding to disposition and what we're going to do? Judge Debra Mcglaughlin said, on the record, I only work Monday through Friday, 9 to 5. There's only so many hours in the day. What makes you think I have enough time to make myself abreast of the evidentiary matters of every case?
What?
Later, after I've completed my 36-week improvement period, she moves to terminate my rights based on the recommendation of the department, which was headed up by my ex-husband's attorney, Debbie Flowers Payne. They all sought my termination. So I filed for the judge's judicial disqualification with the Supreme Court. Judge Debra Mcglaughlin wrote an ex parte letter to Chief Justice Wooten at the Supreme Court. The only reason I got a hold of that letter is because I built a good rapport with the Berkeley County Clerk's office. and I know them by name. They ended up saying, oh, look, there's a letter here. Did you get this letter? No, I didn't get that. So I get the letter, and in the letter, Judge Debra Mcglaughlin writes to Chief Justice Wooten saying, I have no knowledge of the evidentiary matters of this case, despite 10 hotly contested hearings. This litigant is pro se, basically brushing me off. Oh, she's pro se, don't listen to her, she's just stupid. Woman, you just conceded that despite having 10 plus lengthy, hotly contested hearings and coming on to my case after the adjudication, you had no knowledge of the evidentiary matters of my case. So how are you going to engage in a disposition as a neutral fact finder of the court?
And had no interest in even reading through the facts that you purchased, by the way.
Thank you, thank you. So that just tells me right there that you're not a neutral fact finder of the court, that you're rubber stamping everything that the department and
relying on the rest of the department also to give you information.
Thank you. Relying on, not in that, she doesn't even want the fucking information. She can't even read the evidentiary matters of the cases that she's bringing on. I fell into becoming a whistleblower from my own case. I did not come in here seeking to tear down and take down the system. That wasn't at all my case. But what I
Activists are made. They're made.
Literally, I found out, oh wow, my children's attorney is the law clerk to the judge. Oh wow, Debbie Flowers Payne is coming over here and she's talking to the GAL about, oh, I'm getting ready to go to Manchester and there's day drinking in Manchester. And here comes the marshal. Ha ha ha, it's 5 o'clock somewhere. Oh, you guys are so comfortable to talk in front of the judge like this about day drinking? Meanwhile, I'm over here.
They should utilize some of that time to read through transcripts.
Thank you. And not only that, but here I'm a parent with everything at stake. And you all are making light in front of my face about day drinking.
When your life is...
My life is in the balance. I had developed two at-home stay-at-home businesses that were starting to flourish. Both businesses, as a result of this ongoing litigation, have failed. Now I'm doing basic runs and cleaning houses, and I went from having a business that would be generating over $200,000 at this point to virtually nothing.
And you've invested a significant amount into trying to get your kids back again.
$70,000 I spent in less than 2 years in legal costs between the two lawyers. As a result, I had a dog breeding business, a very popular dog breeding business with very famous clientele. My barn was repossessed. I couldn't keep paying on the barn of one of those prefab barns. I had to sell off all the dogs wholesale for pennies on the dollar so that they wouldn't end up in a shelter. So that my entire life, mind you, I'm just starting out. I was awarded spousal support because it was deemed that I needed it to get on my feet. And they took that spousal support and gave it as retroactive support for a man that stole my children. So he's being grossly enriched for acting.
They came out on the top of this situation here. And this Berkeley County judicial system, so many cases, mine, yours, they bleed you dry until you have nothing left. It's like they take away your ability to go and fight them back.
Research and find out, oh wow, Emily Maury is the judge's law clerk. I looked at her background. Oh, I found that article in the journal showing that Judge Catie and Judge Debra Mcglaughlin and the public defender's office, they're all stakeholders in Child Law Services Incorporated.
That's why these conversations here are very important. We are highlighting all of these things and we are bringing it to the public.
Need it.
Yeah, and it's being effective. It's working.
So if you have been violated by Child Law Services Incorporated, that is run by guardian ad litem Catie Wallace, and it was put in place by a judge. All these other judges are stakeholders in these nonprofit entities. Judge Catie is a stakeholder in teen court. So when they're locking up people, they're getting money, state funding on the back end They're getting these tax refunds, tax deductions, $500, max of, they're getting all these loopholes and all this money that the average individual is not going to find. They're not going to see the collusion. You think that you have a fair shot, but you don't have a fair shot. And they've been doing this for so long that it takes for us to get together and stand up and start talking about this. And we have to stop being afraid of being incarcerated, because guess what? You want to incarcerate me? You're going to have to incarcerate all of us then. Hello.
It's already happened to me.
Exactly. Welcome to the club. Welcome to the club. You're not going to get us to stop talking about it. In fact, we're going to join together and we are going to get louder than ever before. And trust and believe Judge Debra Mcglaughlin, Judge Redding, Judge Catie, Judge Faircloth, your days of secrecy are numbered. We know that you all are in collusion. We know for a fact that you all were guardian ad litems together, hemming and hawing and chucking and jiving, and that you know how to bypass judicial safeguards to violate all of our rights, but that the buck stops here.
2026 is a big year for this area. Lots of big changes coming.
2026, we are done with it, and we are going to call you all out. Just like the Epstein files is coming out, the fucking Berkeley files are getting ready to come out too, bitch. Okay? So, yes, if you feel abused, you should, because we're just getting started.
Judicial files. Berkeley County. Berkeley County. That's good though. That's good. Yeah.
We're not going to keep putting up with this. I mean, the things that are going on under the table
Are destroying lives.
are destroying lives. And it's all based on collusion and family. Travis Miller is coming out regarding Steve Redding and Taylor Staubs. And more people, Lynn Rogers is coming out about Debra Mcglaughlin and Child Law Services Incorporated.
Each judge has their own group of people. Like that's what everybody's coming to the front this year.
But they're all together. That's the thing. You can't look at Judge Redding and you can't look at Faircloth without looking at Catie and Mcglaughlin. And Mcglaughlin was a prosecutor for so many years, and she even admitted that she had did a stint. I watched one of her interviews that she had done a stint as a guardian ad litem. I'm going to find everything about
podcast, every interview, every podcast, every judge has ever done.
You all think that you're untouchable, and you're not. We are all on to you.
Surprise!
We're on to you, and we are going to expose you one at a time. You might be able to lock one up here and there, but you can't lock everybody.
And then I'm just gonna put them on camera. Just talk about it.
I have at least 15 other people for you to put on camera, all with the same entities: Steve Redding, Debbie Flowers Payne, Tracy Reese. Like it's like the same villains.
There's so many, but it's the same thread of injustice. Of the same thing is happening throughout the entire thing.
With the same parties.
The interconnectedness of this system needs to go.
It needs to go. And not only that, but the problem is that these judges are engaged in extortion, fraud, money laundering. What they're doing is they're formulating these nonprofits, and they're getting state and federal funding on the back end for these nonprofits that they're developing, and they're seizing us of our rights.
They're so used to doing what they're doing. That's the problem. That's where we're at now. It's been things have been happening for so long. I feel honestly like they think it's normal.
Yeah.
Like this is how it was. This is how this system operates. And that's why they get so appalled. Like, what do you mean? Like,
and they have no sense of empathy. They have no sense of, they're not humanitarians. We need people that are in these positions of power that are humanitarian, that are more remedial as opposed to punitive. Everything is not punitive. You don't have to destroy everybody's life. Don't you want to remedy some people's lives? They're not here for that. And those are the people that need to come out of power. But then again, some of them were appointed in by their buddies, like Debra Mcglaughlin.
There's so many connections. Like so many judges I know have hired in, or they've appointed their clerks, family members. It's throughout the entire
It is.
courthouse.
It is. Well, I would like for everybody, if you can, to please, it will be telecasted on the webcast through the website. If you cannot make it to West Virginia University Law School on April the 1st at 11 a.m., we are having a watch party. I need court watchers there because we need to hold these individuals accountable.
We'll be there. Our team will be there. So,
Hello.
so after your hearing in Martinsburg, we're going to have a meet and greet. We will announce the time for you guys later, but it's going to have Travis Miller, John Pierce, who is a Harvard attorney. We've got myself, Shane Corey, and who am I missing? Anybody? I think, yeah.
And everyone who is a CPS advocate or a victim is welcome to come out. Please stay tuned to our pages on social media. We need everybody to come together because strength comes in numbers.
And I think it's going to be a really good idea to everybody who's involved in this movement to come to this meet and greet, because we get in person, we form community, and that's how you organize.
So they don't want us to get together and start forming connections. So they want to keep this labyrinth of mystery, but guess what? We've got your number.
What's happening now with everybody coming together, I can only imagine. They are losing it.
We are going to rise up against you and trust and believe we are done.